If you are planning to file your I-485, your application to adjust status to a lawful permanent resident, stop right now. Do not submit that application until you watch this entire video, because in the last 30 days, USCIS has made not one but multiple critical changes that could get your I-485 rejected before it even reaches an adjudicator's desk. We're talking about new filing charts, updated form additions, a proposed DHS rule change, and a nationwide enforcement initiative called Operation Twin Shield, all of which are directly relevant to green card applicants filing right now. This is not fear-mongering. This is factual, documented policy analysis. And if you file using outdated information, you could face rejection, lost filing fees, and months of delay. So stay with me for the next 14 minutes because this could be the most important video you watch before you file. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. I don't do rumors. I don't do clickbait. Everything I cover is sourced directly from USCIS, DHS, the Federal Register, and official court records. My job is to translate government policy into plain English so that you, the applicant, the petitioner, the family member waiting, can make informed decisions. Before we go further, I need to be clear. I am not your attorney, and this content is for educational and informational purposes only. Always consult with a licensed immigration attorney about your specific case. What I provide here is analysis, not legal advice. All right, let's get into it. Change number 1, the February 2026 filing charts. Chart A versus Chart B. Let's start with the one that is tripping up the most applicants right now. Every month, the State Department publishes the Visa Bulletin, and inside that bulletin are 2 charts for adjustment of status applicants. Chart A, dates for final action, and Chart B, dates for filing. In February 2026, USCIS has authorized the use of Chart B, the dates for filing chart. This is significant. Chart B allows applicants to file their I-485 earlier than Chart A would permit, even before a visa number is technically available, as long as USCIS formally approves Chart B use for that month. But here's where this becomes critical. If you look at the wrong chart, if you assume Chart B is always available or always more favorable without confirming USCIS's monthly authorization, and you file based on that assumption, your application could be rejected outright. USCIS is strict about this. They will not adjudicate a prematurely filed I-485. You will lose your filing fee. Your case will be returned. So the rule is simple but must be followed precisely. Before you file any I-485, you must go to the official USCIS Adjustment of Status Filing Charts page. I'll put the link in the description. Confirm which chart USCIS has authorized for that specific month, and confirm your priority date falls within the authorized range under that chart for your specific preference category and country of chargeability. This applies whether you are family-based, employment-based, EB1, EB2, EB3, or any other category subject to numerical limitations. Change number 2, new form additions, I-765 and G-1055 updated in February 2026. This is what many green card applicants are misunderstanding right now. USCIS has released updated editions of 2 critical forms in February 2026. The Form I-765, which is your application for employment authorization, your work permit, and Form G-1055, which is the official USCIS fee schedule. Why does this matter? Because USCIS is strict about addition dates. If you file using a form addition that is no longer accepted, even if the content is nearly identical to the current version, USCIS will reject your application. This is not a technicality they overlook. It is an automatic rejection trigger. The I-765 is commonly filed concurrently with the I-485 as part of an adjustment of status package. If your I-765 is on an outdated edition, your entire filing package may be rejected. And the G-1055 fee schedule update is equally important. USCIS fees change. If you are submitting a check or money order based on outdated fee information, your application will be rejected for incorrect payment. Before you file, go to the USCIS Forms page, again, link in the description, and download every form directly from that page. Do not use forms saved from previous filings. Do not use forms from third-party websites. Always download directly from USCIS on the day you are preparing your application package. This is one detail most people are missing, and it's a fixable mistake that causes entirely preventable rejections. Change number 3, the proposed DHS rule. EAD eligibility for asylum applicants, February 20th, 2026. On February 20th, 2026, the Department of Homeland Security published a proposed rule, And I want to be very precise with that language. A proposed rule, not a final rule, that would significantly tighten work authorization eligibility for asylum applicants. Under current law, derived from the Immigration and Nationality Act, most asylum seekers become eligible to apply for an employment authorization document after 180 days of a pending asylum application. DHS is now proposing to add additional screening requirements and eligibility criteria before that EAD can be issued. Now, if you are an I-485 applicant and not an asylum seeker, you may be wondering, why does this affect me? Here's why it could. This could affect you even if you're not in this visa category. Adjustment of status applicants often file Form I-765 for an EAD as part of their I-485 package, deriving work authorization from their pending adjustment application rather than from asylum. But DHS rulemaking in the asylum space often signals broader enforcement priorities and can affect related regulatory guidance. More importantly, if any family members or co-applicants in your household have pending asylum claims, this proposed rule could directly impact their ability to work while your family's immigration case progresses. Because this is a proposed rule, it is currently in the notice and comment period. It has not taken effect. But under the Administrative Procedure Act, once the comment period closes and DHS issues a final rule, it can take effect quickly, sometimes within 30 to 60 days of finalization. This is a situation worth monitoring closely with your immigration attorney. Change number 4. Operation Twin Shield, USCIS Fraud Enforcement Initiative. This one carries serious implications for people with complex immigration histories. USCIS has launched Operation Twin Shield, a targeted enforcement initiative focused on auditing existing records for evidence of marriage fraud and identity fraud. Under this operation, USCIS is going back into their systems and cross-referencing petitions and applications where fraud indicators have been flagged. This includes I-130 petitions based on marriage, prior immigration applications that may have involved identity inconsistencies, and cases where there are discrepancies between records across agencies. However, this protection may not be permanent. If USCIS discovers fraud indicators in your historical record, they have the authority under the INA to deny a currently pending application, including an I-485, and potentially refer the matter for further investigation. This does not mean that everyone filing an I-485 is at risk. The vast majority of applicants have clean records and nothing to worry about. But if you or your sponsoring petitioner have any prior immigration history that involved errors, inconsistencies, or applications that were withdrawn or abandoned, you need to review that history with a licensed attorney before filing. Do not file blind. Let me make this real for you with a hypothetical but entirely realistic scenario. Meet Amara and James. Amara is a skilled worker from India, currently in H-1B status. Her employer filed an I-140 immigrant petition for her under the EB-2 category 3 years ago. Her priority date is finally current under February 2026's visa bulletin, but only under Chart B, the dates for filing chart, not Chart A. James is Amara's husband, a U.S. citizen who also filed an I-130 for her 2 years ago as a backup route. They have a young daughter who was born in the United States. Amara and James are excited. They downloaded forms a few weeks ago, gathered their documents, and were about to submit their I-485 package this week. But a friend sent them this video. Here's what they would have gotten wrong. First, the I-765 form they downloaded 6 weeks ago has already been superseded by the February 2026 edition. Second, they calculated their filing fee using an old version of the G1055 schedule. Third, Amara's employer had an I-9 discrepancy flagged 2 years ago, something that could surface under Operation Twin Shield. By taking 1 extra day to verify the current forms, confirm USCIS authorized Chart B for their category, consult their attorney about the I-9 matter, and double-check the current fee schedule, they avoided what could have been a devastating rejection and months of delay. That's what staying informed looks like in practice. Here is your action plan. 5 steps before you file. Step 1. Verify this month's USCIS filing chart authorization. Go to uscis.gov and find the adjustment of status filing charts for the current month. Confirm which chart, A or B, is authorized for your visa category and country of chargeability. Do not assume. Verify. Step 2. Download all forms directly from USCIS on the day you prepare your package. Check the edition date at the bottom of every form. The I-485, I-765, I-131, I-864. Every form must be the current accepted edition. If there is any doubt, download a fresh copy. Step 3. Verify the current fee schedule using Form G-1055 from USCIS.gov. Calculate your fees precisely. If you are submitting multiple forms, make sure each check or money order is correct for each application. Step 4. Review your immigration history. If you or your petitioner have any prior petitions, applications, visa applications, or record inconsistencies, even minor ones, disclose them to your attorney and address them proactively. Under Operation Twin Shield, transparency is far safer than hoping an old issue goes unnoticed. Step 5. Monitor DHS rulemaking. If you or a family member has a pending asylum claim, subscribe to Federal Register alerts for DHS rulemaking and discuss the proposed EAD rule with your attorney now, before it is finalized. Let me zoom out for a moment and give you the bigger picture. The filing chart changes are administrative. USCIS can and does update them monthly. What is authorized in February may change in March. This is an ongoing monthly verification task, not a one-time check. The form edition updates are also rolling. USCIS does not always give advance notice before retiring an old form edition. The best practice is to treat any form older than 30 days as potentially outdated. The proposed DHS rule on EAD eligibility for asylum seekers is still in the notice and comment period under the Administrative Procedure Act. It is not law yet. The public has the opportunity to submit comments to DHS during this period. If finalized, it would take effect subject to the regulatory timeline DHS specifies. But court challenges are possible, particularly from advocacy organizations, which could delay implementation. Operation Twin Shield is an active, ongoing enforcement operation. It does not have a defined end date. USCIS has not published a list of targeted cases. This initiative operates within USCIS's existing statutory authority under the INA and its fraud detection mandate, so it is not subject to the same rulemaking process as a proposed regulation. It is effective immediately and ongoing. Realistic timeline expectations. For most applicants with clean records and properly assembled packages, these changes represent additional verification steps, perhaps an extra day or two of preparation, not fundamental obstacles to filing. But for applicants with complex histories or those relying on asylum-based EADs, the stakes are meaningfully higher. Immigration status is not just a legal classification, it is the foundation of your life in this country. It determines whether your family stays together or faces separation. It determines whether you can continue working, whether your employer can keep sponsoring you, whether your children grow up with both parents present. A rejected I-485 means lost filing fees, potentially thousands of dollars. It means months of delay in an already backlogged system. It means potential gaps in your employment authorization. And depending on your current status, it could mean complications that extend far beyond a simple refiling. This is why I do this work, not to create anxiety, but to give you the information you need to protect what you have built. Stay calm, stay organized, stay informed, and when in doubt, consult a licensed immigration attorney. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. Drop your visa category in the comments below, whether you're EB2, EB3, family-based, asylum, or anything else, and let me know what questions you have about these February 2026 changes. I read every comment. If this video helped you, please share it with someone who is currently preparing an I-485 or planning to file soon. You could be saving them from a costly rejection, and hit the like button. It tells YouTube this is the kind of factual, trustworthy immigration content people actually need. I'll see you in the next one.